They did. So basically, someone's lying to the court.
Your Honor,
I got an affidavit that says we went there and the person said, no, I have no idea who you're talking about. They don't reside here. They don't live here. So who's falsifying their statements to the court? A18-781-255 Harris versus Del Casal.
Morning, Your Honor. Kurt Harris.
Oh, plaintiff first. Go ahead.
Thank you, Your Honor, and I'll be real brief.
Well, no, I just wanted you to check in first, Mr. Harris.
Oh, go ahead.
Just go ahead and put...
Good morning, Kurt Harris, runner 5354 on behalf of the plaintiffs.
Good morning, Your Honor. Charles LoBello, bar number 5052, here on behalf of defendant Michael Franklin.
Okay, go ahead. Now we've got a motion to reconsider. Go ahead.
Thank you, Your Honor. As Your Honor's aware, this is my motion to reconsider. We were in court on April 20th. The order was not very timely. I sent a letter. I wanted to know what the court was because you had ordered at the time of the hearing two things: that they had a 90-day extension, and it wasn't predicated upon notice of entry of order. And secondly, was that the order would be run by me prior to submission to the court. I sent over a letter on or about May 13th looking for the order. I received notice of entry of order on May 19th. I did not countersign, and it indicated that it would be from notice of entry of order, essentially buying an additional 30 days, which was not the order of the court. And so I filed this motion to reconsider to clarify and to make my record. That isn't what was ordered by Your Honor. And specifically, Your Honor ordered that order was to go by me prior to being submitted to the court. At this point, I guess we are where we're at this point. I have objections to discovery, despite the fact that they filed this motion to reopen to do discovery. And I've gotten objections on both sides. So I'm not really sure where I'm at, but this is my motion to reconsider. I did not request a hearing, Your Honor. Needed to occupy Your Honor's time, but wanted to make my record. Thank you, Your Honor.
That's okay. Go ahead. All right, counsel. Explain to me, Mr. LoBello, you've been around long enough, you know. Since when is it ever not the policy of this department, I'm not talking about any other department, not to request that an order be run by the other side?
Your Honor, I am not familiar with the court's policies and procedures. I apologize if that's the court's policy.
Mr. Mueller definitely is. He's in front of me almost every day and has been for the last 5 or 6 years.
No, I can't speak to Mr. Mueller's knowledge, Your Honor.
Well, guess what? He represents the same client and you're partners with him. I always request, demand that orders be run by the other side. We do not play the game of let me try to hide the order and hope no one sees it.
Your Honor, this was a very straightforward motion and order, if I might add.
And why are we here?
Exactly. But when the court asked at the prior hearing of April 20th what relief I was seeking at that motion, I said, Your Honor, we're seeking an additional 90 days from the notice of entry of order. I was very specific in the time period in which I requested, and the court's response was granted. So I put in the order 90 days from the date of notice of entry of the order, and the judge signed off on that. If it was the court's policy for this order to be circulated, I apologize for not having done so, but that doesn't change the fact that the court granted 90 days from the date the order was entered.
What does the local rule require in regards to how long you have to submit an order?
I believe it's 20 days, Your Honor.
14. If I remember right, it's been a long time since I memorized the EDCR, but I think it's probably one of the sevens, probably 7.2, 7.21 or something. There was a big argument about 14 days, how many judicial days that is. So this is what we're going to do, counsel. The 90 days was to run, it was correct. It was to run from the entry of order, a timely entry of order. The orders always are run by the other side, whether they're the most simplistic order in the world. They're always run by the other side so that the court doesn't sign an order improperly. I do not go back and read and or watch the jabs on every single 350 orders I get a week. So this is what you're going to do, counsel. It's for the motions to reconsider. It was 90 days from the date of the timely entry of order. That's the way it's going to be said. So it's, Mr. Harris, your motion to reconsider is denied. It's 90 days from the date of the entry of order, which was to be timely pursuant to EDCR, including the entry of the order. Mr. LoBello, let's do a new order. I want it passed by the other side, denying the motion to reconsider with the specifics that I stated, okay?
Yes, Your Honor.
Thanks, guys. I'll see you later.
Thank you.